But our top story tonight, the big story of the day, is the court verdict that was eagerly anticipated. The Supreme Court today referred a petition that challenged the entry of women of all ages into Sabarimala to a 7-judge bench. A bench headed by Chief Justice of India, Ranjan Gogoi, gave a split verdict, widening the ambit now to a larger bench. That bench could take up cases like women's entry in mosques. Has the court copped out, or has it given an opportunity to redefine that critical issue? What matters more, faith or law? It's our top story tonight.
The Supreme Court order that granted women of all ages entry into Sabarimala, sparking protests by devotees, continues to stand. The court, which was to decide on the review petition challenging the earlier order, has referred it to a larger bench.
Who, in fact, weighed in for and against, in fact, this review petition? The Chief Justice, Ranjan Gogoi, he agreed that the case should be transferred to a larger bench and to take cognizance of the larger questions that have been raised in this. Justice Rohinton Nariman was one of the 2 judges who dissented. He also, in fact, said that this should be, along with the other judge, in fact, who dissented in this, said that this the review petition should be over, should not, in fact, this should be dismissed. In fact, he said that they should go ahead with the 2018 judgment itself. Now, Justice A.M. Khanvalikar, he also agreed for sending this to a larger bench. The other judge on the bench was also Justice D.Y. Chandrachud, who also dissented. He and Justice Rohinton, both of them, in fact, said that this should be dismissed. The review petition, the petition challenging and asking for review should be dismissed.
Chief Justice of India Ranjan Gogoi wrote the majority judgment for himself, Justice A.M. Khanvilkar and Justice Indu Malhotra. Referring the petition to a larger bench, the CJI reasons that 2 earlier judgments took contrary views over essential religious practices. In the Shirur case, the court had held that religious practices should be left to the denomination. But in Dargah Committee case, the court saw a role for itself in the matter. The CJI said this needs to be addressed by a larger bench. The CJI said that pending cases regarding entry of women in the mosques, entry of Parsi women married to non-Parsis in Agyari, and the practice of female genital mutilation in Dawoodi Bohra community may overlap with the Sabarimala judgment. Justice Rohinton Nariman and Justice D.Y. Chandrachud strongly dissented. Nariman, writing the dissenting verdict for the 2 judges, said that the other cases mentioned by the CJI are not before the bench for consideration. He added that a Supreme Court verdict is binding on everyone, and that organized acts of resistance to thwart the earlier verdict cannot be allowed.
I find what is read today in the judgment ringing, profound, very beautifully crafted and clear poetical prose. So I think it's a victory of law and the system.
The 5-judge bench, which was to decide the Sabarimala review petitions, has first sent off the question to a larger bench to answer just what are the extent of the powers of the Supreme Court to decide questions of faith and rights. How does the court balance faith and rights irrespective of which faith is in question, and how far can the court get into interpretation of a religious belief? All those will now be answered by a larger constitution bench. This is Anisha Mathur in New Delhi for India Today.
Let's take a look at what the 2 sides had to say after the judgment. Listen in.
Big relief to the devotees and to everyone who supported the cause of Sabarimala. This is clearly a proof of the fact that there was something wrong that has to be reviewed, and that in itself is a big fruit for all the efforts, for all the hardships that we had to go through.
महिलाओं को उनका जो समानता का अधिकार नहीं मिल रहा है, राइट टू प्रे का अधिकार नहीं मिल रहा है, और पितृसत्ताक जो पद्धति है, जो एक माइंडसेट है, वो कहीं ना कहीं चेंज करने की बारी इस निर्णय के माध्यम से अभी आ रही है। तो मुझे लगता है कि जो लार्जर बेंच है वो भी जो निर्णय देगा वो संविधान ने दिए हुए अधिकार का ही इम्प्लीमेंटेशन करने के लिए निर्णय दे सकता है।
Let's raise the big question then. Does faith come above law? Is the Supreme Court ruling going to be a setback to gender justice or promote it? Will women devotees be blocked in the future? How essential is this particular practice to Sabarimala itself? Is there space now for rationality when it comes to matters of faith? Just some of the questions we'll raise today. Deepa Ishwar, social activist, joins us. She's been leading the campaign against the original Supreme Court judgment. Mihira Sood, lawyer, Supreme Court, joins me, as does Colin Gonsalves, senior advocate. Anand Neelkantan is an author who's been writing on this for a long time. B.K. Biju was an advocate who appeared in the case questioning the original judgment that allowed women entry. Geeta Bhatt is an academic and has strong views on the fact that women should not be allowed entry in the manner that they were. Thank you all very much for joining me at the moment. Deepa Ishwar, are you seeing this as a victory? Can you really see what has happened today as a victory? The court has made it very clear. Women can continue now, of all ages, to go to Sabarimala till the matter is heard. Okay, we'll go first. You tell us, sir. You tell me, do you believe that this is a victory for you? How can you claim victory, as some of you are, when the court has made it very clear that women can continue to go of all ages till the review petition is heard by a 7-judge bench, till the entire bunch of cases are heard by a 7-judge bench?
First of all, the majority judgment today delivered is not saying that women can continue to go, but not saying there is stay also. There is no status.
No, they have said very clearly that women can continue. Day after tomorrow, when the temple opens, it's very clear women can continue to go there till the matter is heard by a 7-judge bench.
No.
In the interim, they can continue to go there.
So, no. It is clearly saying that what is the real issue, Rule 3B. That Rule 3B also gone to for 7 judges bench consideration. So, what is Rule 3B? Rule 3B is saying when ladies are not in a position to enter into the temple, as per the usage and custom, they cannot go. This is what Rule 3B. That para 8 of the majority judgment clearly says that it is also tested by larger bench of.
So you are interpreting this judgment to mean that women cannot go to the menstruating women cannot go to the temple in this intervening period? Is that what you are telling me?
Can you interfere when a matter is sub judice for 7 judges bench, and can you interpret your own way?
Okay, that's this is a matter of interpretation. But Colin Gonsalves, your first reading of what the court has done, has the court essentially chosen not to get into this contentious area of faith and instead left it to a larger bench to interpret the entire gamut of issues? Today it is to do with Lord Ayyappa and Sabarimala. Tomorrow it could be to do with the Dargah, with the Dawoodi Bohra community. They don't want to get into this area just yet.
Well, as far as whether the women can get into the Sabarimala temple, there is no doubt that today's judgment does not stay the original Sabarimala judgment. Women are perfectly entitled to go into the temple to worship, and there can be no restriction placed on them on the basis of today's order. So women can continue getting into the temple, going into the temple and worshipping in the temple, and there is no restriction made today in today's order of the Supreme Court preventing women from going into the temple.
Okay, so you're very clear about that. But the wider issue that I'm going to raise today is, what does this judgment really mean, therefore, for that larger battle between faith and law? Deepa Ishwar, you now join us. Do you really claim victory at the end of the day today? Can you really claim that the judges at no stage are, as of now, even suggesting remotely, as you have been claiming, that menstruating women are to be denied the right to pray in Sabarimala? All they are doing is widening the ambit and taking it to a larger bench.
Rajdeep ji, you know, at every point from the time the verdict came out on September 28th of 2018, at every point that we were taking forward, people have been saying, oh, all the court has done is agree to listen to the review petitions, nothing more than that. And then you say that, okay, all that has happened now is that there will be a 7-member bench which will decide on religious issues, and Sabarimala might be considered. But if you look at the big picture, we've come a long way from where the verdict had initially come out. When the verdict had initially come out, there were a lot of people who actually, even including senior lawyers, who told us that nothing is going to happen. You cannot do anything about it. The review petitions will be dismissed right from the chamber of the Honorable Chief Justice. But then the review petitions were heard in the open court. Today, the verdict was pronounced in open court, and the verdict says very clearly the review petitions were not rejected. At least that is clear to everyone. If there is a lot of ambiguity in the verdict, I agree, but then at the same time, one thing is very clear, that nobody has said that the review petition stands dismissed or rejected. That itself says that there is a need to keep it pending, or there is a need for a larger bench to examine various religious issues, after which we will see if this verdict is flawed or not. So which means that there is a possibility in future where this verdict could turn around, or or a flaw could be found out in this particular verdict. So I think that has to be accepted on the face. I don't understand why everyone finds it so difficult to accept that yes, there has been a partial relief to the devotees. None of them have even felt like telling us that yes.
Just a minute, let Meera Sood respond. Meera Sood, respond. Is there a sense that those who've been advocating gender justice and believing that the rights of women of all ages to pray are superior to the so-called devotees' rights to ensure that certain women cannot pray? Do you believe that this judgment is a blow to that extent of gender justice? The court did not firmly reaffirm the rights of women. The majority judgment certainly did not firmly reaffirm the rights of women to pray in Sabarimala.
Rajdeep, first of all, I reject this false dichotomy between gender justice and the rights of women and the rights of devotees. Women are as much devotees of the deity at Sabarimala as any other class of devotees. So this dichotomy is completely false, and I reject it. Secondly, I think what has happened today in the Supreme Court is a travesty of constitutional procedures, quite frankly, because this is not anymore about agreeing or disagreeing with the verdict, the original verdict by the 5 judges, the 4:1 verdict that allowed entry. This is a matter of constitutional propriety. Let me explain. A review petition is maintainable only if there is an error apparent on the face of the record, or some new evidence has come to light, or some other such similar reason. It cannot be treated as an appeal. You cannot re-argue the same issues and hope for a different outcome. And for the Supreme Court to allow this review, to say this review is maintainable without even addressing what is the error that has come forward, that has been brought forward now that they were not aware of earlier, is a complete mockery of constitutional procedures.
You know, that is the procedural aspect. You are claiming constitutionally it's flawed, but I want to look at the sum and substance of what the court has done today. Anand Neelakantan, you are an author who's been writing on this issue. Do you believe that the court finds itself in a bind because there are the rights of the devotees and there are the rights of women? There are the rights of the priest to decide who can enter a temple and who cannot, and there are the rights of women to actually enter a temple of their choice. Do you believe the court is worried that the moment we enter these issues of faith and ancient practices and traditions, we are entering a very slippery slope, as the majority judgment seems to indicate? Today it is to do with Lord Ayyappa's devotees, tomorrow it could be Dawoodi Bohras, third day it could be the Parsi community. We do not want to enter this tricky area.
Well, Rajdev, I think this is a very unfortunate decision. Actually, I doubt whether we can call this a decision at all. This is a ridiculous kind of thing the Honorable Court has done. It has neither said yes nor said no. Now imagine this case, now there is no stay for entering the Sabarimala temple for women of any age. now they enter, later, say after 5 years or 6 years, the 7-member committee decides they cannot enter, then it is like insulting the belief. If the police stops them, then it is like not respecting the court. So this is a quandary. This will benefit only the politicians. This is not what is expected from the court. The court has to say either yes or no. This court has said both. They have said yes and no, and this is going to create great law and order situation in Kerala, because the state government will be bound to do what is expected from a government and follow the Supreme Court judgment, which has not stayed the woman's entry, whereas lot of devotees are going to come and going to stop it. So this is virtually, we are having a law and order problem in our hand, and this is going to destroy.
You're saying the judges have copped out.
Pilgrim place.
Essentially the judges have copped out. They have chosen not to enter a tricky area. The judges have chosen by opting out. The judges have left it so ambiguous that you are saying that the conflict will continue and will continue to simmer in a way. Geeta, you want to raise that issue, because the fact is that the judges are making it very clear, particularly the minority judgment
is going to explode. It is not going to.
You're saying it's going to explode because you've got a situation now where organized protests took place.
Is not going to simmer.
The last time when it happened, there were organized protests to stop the judgment from being effected. And the judges have made it very clear. You cannot take the law into your own hands. Tomorrow we'll have, again, as Anand is suggesting, you'll have people stopping women from entering the temple.
Rajdeep ji, while this question has come that the state government of Kerala is going to, face very tough times, now I want to bring couple of points. First point is related to the state government. Why this judgment which came in the very first place itself, the state government, the submission by the state government in the court itself, without taking into consideration what the local community feels about this whole issue, they went ahead and made their own submission there, because of which when this judgment came, just give me 10 seconds. When this judgment came, they were hell-bent on implementing it. At the same time last year, there was another judgment which came for a very long battle which was going on between the Christian communities, the Orthodox community as well as the Jacobites over a church property. That decision also was given by the Supreme Court. However, for that, very conveniently, the CPM-led government in Kerala said and took out an order and asked the Supreme Court to give time to implement that, because it could create a law and order situation. I mean, look at this contrast. For one judgment, they said that we will go ahead, and they were hell-bent on implementing it. And on the other side, when it came to Christians,
is it not the duty of any state government to implement the court judgment, whichever the denomination?
No, but the point is that why is it that they are having these double standards? It is very, very clear that time and again, and in fact, even the board, which is governing administratively the Ayyappa temple, that also had the dominance of the CPM government. The representatives were there, and that is why
you're making a point about double standards.
Yes,
let's just look at that.
I want to
just 1 minute.
Three things more also over it.
No, 1 minute. Let's get everyone in. Let's look at the double standards. Colin Gonsalves, are there fundamentally double standards in the way court judgments involving religious issues are implemented? And that in this particular instance, that's why the judges have decided, let's go to a larger bench. Let's look at the entire gamut of issues that involve such gender justice versus faith battles. We cannot discuss the Sabarimala issue in isolation.
Well, Rajdeep, the core issue, which has been debated in the Supreme Court from 1952 onwards, the core issue is when people have a religious belief like in Sabarimala, that their religion prohibits women from coming into a temple, or any other religious belief which is contrary to the equality clause of the Constitution, what will survive? The religious belief, the backward religious belief, or the constitutional principle? And in the Sabarimala case, the court said three things. Even if exclusion is founded on religion, it is subject to the Constitution. Exclusion on the basis of menstruation has no place in the constitutional order. And finally, exclusion of women amounts to untouchability. Purity and pollution have no place in the constitutional order. Rajdeep, the original Sabarimala judgment, was a historic judgment which cleared the way for gender justice and said, no matter what your religion is, if there is any aspect which is anti-woman, Article 14 of the Constitution will prevail over that religious belief, which is equality between men and women. Historic judgment, which even today the court has not stayed.
Rajdeep ji, I want to add one thing.
Very quickly.
Yes, I just want to, ask sir over here that if tomorrow there could be another PIL which might say that, why is it that the confessions in the church are only in front of a priest? Why not nuns? Someone can go and question. Then what is going to be the stand? What kind of a judgment the judiciary is going to take?
Colin, you want to quickly respond to that because you did respond to that, and then I'll respond to the fundamental point I also raised,
yes,
which is being raised. Is there a double standard in the way in which the court has dealt with this issue, and the court now wants to end those double standards?
No double standards in the court. Court says any religion, Christianity, Sikhism, Buddhism, any religion. If you discriminate against women and you say, my religion allows me to, the court will say the court will not allow you. And in Christianity, there are so many discriminations against women. You can only have men priests, as the lady correctly pointed out. All that discrimination against women, because their religion says you can do discrimination against women, all that will come to an end.
But there are other judgments. There are many judgments.
Right.
Yes, very quickly. Do you agree that what the court is saying is that we are taking it to a wider bench so that women will not be, there will be no discrimination against women in all faiths?
Rajdeep ji, first of all, for you and Colin sir, in the earlier judgment, paragraph 144, subclause 2, Justice Deepak Mishra and Honorable Justice Kanvilkar clarified that right guaranteed under Article 25(1) has nothing to do with the gender, or for that matter, certain physiological factors specifically attributable to women. So there is nothing to do with the menstruation. 3 judges were in favor of us in that case. And Justice Sindhu Malhotra said we are touching on the testing with the constitutional validity.
Hers was the dissenting judgment. The majority judgment, even in the earlier case, made it very clear you cannot exclude women on the basis of menstruation.
Yes or no? On the basis of menstruation.
On any basis. On any basis, women cannot be excluded was the earlier judgment. Yes or no?
Because of today's judgment also, just what Colin saying is to the extent correct. Why? That is the constitutional Article 25-26 giving. It is in preamble of the Constitution, right to worship, and it is further qualifies Article 25 and 26 saying that you can have your right, and Article 26 especially clear that establish and maintain.
Okay, very quickly, yes ma'am.
Article 32 of the Constitution very categorically says that when a PIL is filed related to religious matters, then there have to be the code, the devotees should be there, who should be those who should be filing the case. However, in this case, and that is what was raised by Justice Sindhu Malhotra, she said you will be opening a Pandora's box if you try to get into this nitty-gritty.
Okay, just a minute, ma'am. This is the view that the RSS has made, which they've gone to the ground in Kerala and said it opens up Pandora's box.
I want to ask
Meera, just a minute now. Please let the others. Meera suit, does it open a Pandora's box? Those who advocate gender justice today, is the fear that is being expressed by the other side, it exposes a Pandora's box. Tomorrow in a dargah, which prevents women from entering, you will have to allow women now to enter.
Haji Ali Dargah, women are not allowed to enter there.
Christian woman wanted to be a priest.
But Rajdeep, listen to me. Yes. I find it really remarkable that people who are speaking out against regressive practices in other religions are against this judgment. They should welcome it, because every other case, whether it is Dargahs, whether it is the Dawoodi Bohra case, whether it is Parsis, any other religion, any other case, to the extent that the issues are similar, they will be bound by the Sabarimala judgment. So I don't understand this point of saying Why do you only do it for Hindus? You don't do it for other religions. The fact that you've done it by a 5-judge bench in Sabarimala case means that other cases will be bound by this to the extent that the legal issues they raise are similar. So people should be welcoming this judgment because it will apply to all religions.
One minute. First of all, unfortunately, that would have been the case if the 5-judge bench would have reaffirmed what they had said earlier. Now they've sent it to a wider 7-judge bench. But Deepa Ishwar, you've made it a point at the end of the day to suggest that this is specific to Ayyappa sect. The fact is, let's be very clear. The court wants to use the wider issue of gender justice. Why should a menstruating woman be treated in some way as impure? Would Lord Ayyappa do it? Let's be very clear. You are speaking for Lord Ayyappa as if the deity would sanctify the act as impure. And the court doesn't want, the majority judgment also is making it very clear. We don't accept this argument.
No, I think what we've been... No, I think what we have been talking for is not about menstruation. We've been talking about the character of the deity, the rights of the deity, okay? So the character of the deity is that the deity is celibate. Now, the next question that came was who decides that the deity is celibate? Or even if that is the case, who decides that young women should not come there? I think one of those important questions of the 7 questions that needs to be addressed by a future 7-member judging panel would be definitely as to who is the final word in deciding this. Is it the court, or is it the person, or is it that head who actually heads that particular religious sect or that community? So I think once that decision comes out, that okay, it is the tantri, in our case it's the tantri, if it is that supreme priest who decides that, then that is the nature of that particular temple. It's not that women are banned entirely from Sabarimala. It's only an age regulation for the women there. So obviously it's not gender discrimination that we're talking about. So I think that important question of who is the final word in deciding these kind of things is something that we need to wait and see. Another thing that I'd like to point out is that as long as the court has observed that the review petition deserves to be...
No, let Anand Neelakantan answer that question. Anand, I've been reading what you've been writing, where you've suggested that it cannot be the right of the priest. It cannot be the right of the priest to decide who enters or who doesn't, particularly in the case of Sabarimala. Do you hold on to that? Do you believe that that fundamental question needs to be answered? Who decides?
And who else?
No tantri, no religious head is superior than the Constitution of India.
This is Thakur's judgment.
If the court had decided that the woman has to enter, they will enter.
So the Constitution decides the character of the deity.
The Constitution of India is more superior to any religious belief. We live by the Constitution. Anything is below that. Whether it is a religious head of any sect, whether Hindus, Muslims, anybody.
So the fundamental point you are saying...
what has happened now, the court has neither said yes nor said no.
Yes. I agree. No, I agree that the Constitution is superior.
No, Deepa, do you accept that somewhere constitutional...
can definitely not comment on the character of the deity in a particular temple.
The tantri cannot decide against the Constitution. The Constitution, if it guarantees, if the court decides as it did in its original judgment...
And the court cannot decide, and the court... Parallelly, Rajdeep ji, if the tantri cannot decide on what happens in a temple or what happens or on gender equality, the court cannot decide on what happens in a temple as well. How can a court know what is different in Sabarimala than the other Ayyappa temples? So there needs to be a balance. We all agree that Constitution is superior, but you cannot take a magnifying glass made of materials of a Constitution and look at every ritual of a temple and say that this is against the clause of a Constitution. Neither can you go about every temple and say that, oh, I'm not going to bother the Constitution. It has to be exactly what my faith believes in. There needs to be a balance between the two.
Okay,
you cannot say that because this ritual is against the Constitution,
I come back to it.
In that case, what about Article The only ladies who are offering the Article Kungala. Do you tomorrow say that that's against gender equality and that has to be taken off?
Yes, Anand, you wanted to respond. Very quickly, Anand.
See, there are 2-3 things here. First of all, naturally, this would have happened, this kind of reforms happen in the society. Hinduism have been reformed many times, sometimes through legislation, sometimes through the work of saints, sometimes through the work of reformers, sometimes through the demand of the people. Now, what this has become, 2 political parties in the states, in the Kerala state has taken this as an ego issue, and they are fighting it out on the street. And it is unfortunate that the court has not taken a decision either yes or no by leaving it to the 7th bench. Now it is going to be a law and order situation. This has become a political ego problem now, nothing else.
Okay, that's
it's not that the traditional
you made that point that is true. No, that is true. At the end of the day, this is a political battle. Let's be honest, the BJP government, which says we respect the judgment in the Ayodhya case, whatever it will be, didn't do that in the Sabarimala case. After the original judgment came, they encouraged their people to hit the street. Let's be very clear, there is politics involved in this.
It is not like that.
It is.
In Ayodhya judgment, it is very clear. Page 115, it is very clear.
Today, the court has said very clearly in Sabarimala, you cannot have organized protests to stop the rule of law. The rule of law is to be enforced.
Of course, we are. No.
Tomorrow, if there is, answer me a direct question.
One second, sir, 1 second.
If a menstruating woman,
it has nothing to do with the menstruation.
1 minute, sir. If a woman tomorrow, 3 days later, when the Sabarimala temple is opened, wants to go in, will you stop her or not? Will the political
you use the word menstruation. That menstruation is nothing to do with the earlier judgment or person. Number one. 1 second. What was the Ayodhya's judgment? Ayodhya very clear. Page 115 says that if it is religious issue, we are not theological or ecclesiastical court. We have our limitations.
Yes.
We are secular institution. We cannot go into it. I argued before the court the same lines. So therefore, is Colin Saab is a authority under ecclesiastical? Are you? See, again and again saying, sir,
you're saying the court cannot enter this tricky area of religion or religious faith involving a sect, right?
Let us wait till the 7 judges judgment.
Okay.
Rajivji, I just want to add one thing. See, as per the Hindu law, the deity is a juristic entity. And as a juristic entity, which also has been quoted in the Ayodhya judgment, the deity has full rights under Article 21, just like you and me. And it
those
was
rights cannot be against the constitutional values of the country.
No, the point is that the same argument was used in the 1980s during Rajiv Gandhi government to get an Nataraja Murti, which was of during the Chola Empire and it was argued in the British courts, and that is how that Murti was brought back into India. It is the same argument which was used.
Only 1 second, sir. Only 1 second. What is saying, Justice Nariman's judgment today, we respect both. See what he says, even in the minority judgment today, in the last paragraph says that for the implementation of the judgment, please sit to all the concerned parties and accordingly decide things. Therefore, the earlier affidavits filed by the concerned parties, government did not have an appropriate discussions with the concerned parties.
Essentially,
so therefore,
1 minute. That is your interpretation
of
the
judgment.
No, it is your interpretation.
In the judgment.
Colin Gonsalves, therefore, at the end of the day, now that it's gone to a 7-judge bench, do you believe that this tricky issue of law and faith continues to remain contentious, has not been decided once and for all?
No.
Well, it's not a tricky issue at all. Yes. The 5-judge bench in Sabarimala have cleared that issue completely. There are 3 judges of a 5-judge bench now don't have the conviction to stand by the Sabarimala judgment is a matter of regret. And I doubt if in the years to come, a larger bench of 7 judges will interfere with Sabarimala at all. Today's aberration, if you like, today's unfortunate situation where 3 judges gave a wrong judgment to keep the review petitions pending, I believe a future bench of 7 judges will confirm Sabarimala decisively and say that the review order was wrong. I believe that. That is what is going to happen.
There is error apparent on the face of the record. For 1 second, what is the foundation of the judgment of my Lord Justice Nariman, Justice Chandrachud? The affidavit of Tandri. What is the basis of affidavit of Tandri? It is Tantra Samchayam chapter 10. he misinterpreted chapter 10 is nothing to do with Ashuddha menstruation. So therefore, error based on the apparent of the record on facts as well as the legal.
Again, it is your interpretation. Had that been the case, the minority judgment would not have been as clear-cut as it is at the moment, which reaffirmed the original 5-judge bench. It is 3 judges now who have in the majority judgment decided to send it to 7 judges. Clearly, therefore, the issue will continue to boil. And that's the fear that some have, that Sabarimala could explode once again when there is entry, when the temple opens again in a few days' time. Appreciate your joining us and giving us your different perspectives. My take. The Supreme Court decision to refer the contentious Sabarimala case to a larger bench leaves more questions than answers. The majority judgment, for example, says faith and religious beliefs is an area where the court must tread carefully. Ironically, it was just 5 days ago when the apex court in the Ayodhya judgment referred to faith as an important factor when upholding the rights of the deity Ram Lalla Virajman to the disputed land. Ayodhya was a title dispute. Sabarimala is a classic case where the faith of the followers of a sect must be measured against constitutional values. Prima facie, it would seem patently immoral and absurd to hold that menstruating women are impure and then justify discrimination against them. Even if one refers to tradition, it is hard to imagine in the 21st century that the supreme deity would find a natural process to be impure. The original majority judgment had placed the constitution and gender justice over tradition and religious beliefs. Now, by refusing to give finality to its original order, the court seems to be dithering. Surely the protest by politically aligned groups taking law into their own hands should not have been a deterrent. We live in the age of social reform, where a woman's right to pray must surely take precedence over the rights of priests to decide who will visit a temple and who will not. We expect our judges to be a step ahead of society, not lagging behind the times. Okay, let's take a break at this point. When we return, we'll turn to the day's other top stories.